all. My name is Sonja Wachter. I'm Professor of Technology and Regulation here at the OII. Very wonderful to see you all. Very happy welcome to everybody who is joining us online. I'm really excited that you could all come today to our book talk, The Privacy Fallacy, Harm and Power in the Information Economy. We're super delighted to have a wonderful speaker here. Professor Ignacio Cofone is going to be here with us today presenting his latest work, which is really interesting. It's thinking about how AI and inferences are changing the social and economical and political realities of our world, and how that impacts how we should regulate things and what it means for the law. Ignacio is the Canada Research Chair in AI and Law and Data Governance at McGill University, Faculty of Law. He's also an affiliated fellow at the Yale Law School Information Society Project. And now at the moment, he's a fellow at Magdalen College, which is fantastic. So he's going to be with us for quite some time now. I think it's a treat for all of us because the book is really thinking about an issue from a multidimensional perspective, interdisciplinary perspective, looking at social, economical, political realities. So that's really exciting. I'm really great that you could make it today. Just 2 points for housekeeping. This talk is being recorded at the moment, so be aware when you're raising your hand and saying something that this will be recorded. For those online, if you want to ask questions, just put them in the Q&A function on Zoom. I will come to them after the talk. If you would like to pose your questions by yourself, then just raise the hand in Zoom and I will call on you. For everybody in the room, just wait till the end of the talk and then we're going to come to your questions. I think the talk is going to be roughly 30 odd minutes. Other than that, I think that will be everything. Wonderful to have you here and the floor is for yours.
Thank you very much. So thank you very much, Mr. Wachter, for inviting me for that overly kind introduction. And thank you all for being here. I'm very happy to get the chance to talk about this with you. So I wanted to talk roughly about 3 things to get the ball rolling, but I'm happy also to discuss anything else that you're curious or interested in. And the first thing that I wanted to talk with you about is the problem, which is harm in the information economy. About 30 years ago, the law was deeply unfair to Pamela Anderson. Some of you may remember, and some of you may have read in her autobiography, in the mid-90s, someone stole a VHS tape from her garage. For people under 30, a VHS tape was a really big thing that we used to record and watch videos. And she was intimate with her husband, Tommy Lee. The people that stole the tape also leaked it to the internet, in which it was disseminated. And Penthouse magazine decided to take stills from the tape and publish them in its magazine to make money out of it by selling copies. What you may not know is that Anderson sued Penthouse magazine, and she lost, largely because the judge had determined that because naked pictures of her had been already online, she had no interest that was protected by the law in those pictures. Why am I telling you this 30 years later? Because the judge failed to see something that we do see now for a case like this one, but we miss for many other cases, which is that the interest that this person had was dignitary and was beyond the commercial interest that she could have over those pictures. And because Pamela Anderson was one of the first examples that we have of someone that was pulled into the information economy, which is a commercial system in which companies profit not only from the money that we give them, but from the information that they take from us. And oftentimes, that means that people are exposed to a number of harms of which they're not aware and which they didn't agree to. Most of the harms in the information economy look a bit different. And Cambridge Analytica in 2018 was a good example of that. Most of the harms in the information economy today do not target one particular famous person, but rather affect large numbers of people, sometimes groups, sometimes vulnerable groups, in a way that is dispersed. Cambridge Analytica implied harms to democracy that affected lots of North Americans. Other software systems, like systems that are used by the police to predict criminality, affect marginalized groups when they have error rates in their predictions. This makes harms more difficult to see because the parties involved not always know that they've been harmed, and much less they're able to predict the harm before they happen. And to prove that, that's me. Nothing terrible happened to me, but this is Premise, one of the many facial recognition companies that offer services to the public. If you want to make an account, I think it's about $25 a month, and it's great for stalkers. Kashmir Hill, who wrote a fantastic book on facial recognition, did me the favor of running my faculty profile picture through the paid version of the software, which gives you more access than the free version. And I thought, what could she possibly find? I'm a boring law professor. She'll find 10 pictures in conference, and she'll find pictures of a bunch of people that are not me, but look like me. And I was deeply wrong. What I saw were hundreds of pictures of me, 0 pictures not of me. Some of them, like this one, where I was actually officiating the wedding of a data protection lawyer, and some of them, like this one, in which my face is 3 pixels in the background of a club 15 years ago, in which no one would have noticed my face there. But although no one was watching me that night, the information economy is always watching. And this is to show that you don't have to be famous, you don't have to be important, you don't have to be anything to be part of the information economy. We're all part of the information economy and the risk that involves, because data is just the way that we live our social and economic lives. And the law has been wildly inadequate at dealing with these risks and with these harms. And thus largely because AI, to a large extent data processing before AI, but to a large extent AI, has changed the way that these harms take place, and has changed the way that society functions in a way that makes it different from how the law assumes that these relationships work. To a large extent, privacy law and data protection law is built on a consumer model, where it assumes that there's one person interacting with one company, and that person is giving data to that company, where that person ought to be given choices, and we ought to give transparency about the data processing. We ought to give choices to the people. So in that way, they can choose what data interactions are good for them and what data interactions are not good for them. But that fails for 3 reasons that AI creates. The first reason is inferences, something that Professor Wachter has written extensively about. A couple of years ago, TransUnion, one of the large credit rating agencies that determine our credit scores to see if we get loans, or in some countries to see if we get apartments or jobs, mistakenly inferred that a couple of hundred people were terrorists. Those people didn't get the car loans, the apartment rentals, the mortgages, and the jobs that they were applying to, but it was very difficult for them to show why or how. And more importantly, it was difficult for them to show what they had in common. When the case got to the US Supreme Court, the class action lost, because the Supreme Court said that the 500 people that had been subjected to the same inferential data practice had nothing in common to be grouped as a class. Some of them didn't get cars, some of them didn't get jobs, some of them didn't get apartments. But the Supreme Court didn't see the same thing that the judge in the Anderson case didn't see, that there was a privacy harm beyond all of those consequences that they faced that allowed them not to be grouped as a class. Inferences make it so that the model that we have, where we treat data subjects as consumers, doesn't work, because it is impossible to predict the risks that our data involves. Each piece of data that we release is like a piece of a very large puzzle. And we may have an idea of the piece of information that we give, but we have no idea of the puzzle that gets formed about us on the back end. So in consumer relationships, our interaction starts and ends the moment that we approach a cash register. If I go buy a pair of shoes, I'm gonna go to the cash register, give a certain amount of money, I will walk away with the shoes, and the worst thing that can happen to me is that I don't like them and I waste the money. But in the information economy, our interactions happen second by second, and they follow us forever, because they create these inferences over it is impossible to give us any form of meaningful control. The second reason why this model fails is that information is relational. A couple of months ago, you may have heard that 23andMe had a couple of its accounts compromised by hackers. 23andMe is a company where You can order a box where you get a swab, you can swab your mouth, send it back, and they will send you an analysis of lots of interesting information on your ancestry and your propensity for certain diseases. The problem that the hack had with 23andMe is that the hackers didn't only get access to the accounts that were compromised. The nature of genetic data is that data about any of us is also data about everyone that is related to us. Every time we send a swab to 23andMe, Ancestry, or any other genetics company, we're not only giving information about us, but also about a lot of people that share part of the genetic material with us. So the hackers got access to a number of profiles, and now there are lists of people based on their ancestry for sale in the black market that could lead to all sorts of risks. But the issue is that in the information economy, the relational nature of data is not only for genetic data. Every information is relational because the inference that are made about us are inference about groups and are inference about behaviors and are inference about trends that escape each individual that shares the data. If I interact for the first time with a data company, they may not know anything about me, but if they know some of my demographics, they will be able to probabilistically infer lots of information about me, because if they know my gender, they know my age, they know whether I live in an urban environment, they have lots of information about people with those characteristics that help them infer how I may behave, how I may act, and what I may like. That means that if we're using a consumer protection model where we're trying to give people options, we're allowing people to consent for information on behalf of others. And consenting on behalf of others breaks even the thinnest notions of consent that the law has handled so far, making it ineffective to protect people. And the third reason for which the model that we have for the basics of privacy and data protection law fails is power. This is the picture that ProPublica, an investigative journalism agency, put when it released an article on Compass. Compass is an algorithm that measures recidivism rates in the United States. So Compass offers judges in different states the ability to measure for them what is the likelihood of someone that is being evaluated for bail or for parole has to committing a crime if they get released. ProPublica found by reverse engineering Compass that it was much more likely to mistakenly flag Black and Hispanic individuals as high risk, and it was much more likely to flag white individuals as low risk mistakenly. The thing is that the error rate is not the only meaningful difference that software like Compass have in the way that we interact. Because by making significant decisions about our lives, even beyond criminality, also in terms of employment where CVs get screened, credit scores to determine whether we get loans, in a way that is centralized, that shifts relationships of power. 10, 20 years ago, maybe more, if we went to get a mortgage loan, we would have to go to a bank teller, and the bank teller would make an individual assessment about us, would see how much money we make, how much money we want to spend in the mortgage, and make a determination about whether we should get the loan. Today, that gets determined by an algorithm. That means that hundreds or maybe thousands of bank tellers' discretion gets replaced by the discretion of a few algorithmic designers that make decisions for everyone. That's not necessarily a bad thing, but it does shift the way that we interact with those decisions because it concentrates power, and it means that an error in those decisions gets magnified, gets perpetuated, and gets amplified. So for those three reasons, the way that we tend to think about harms in the information economy has been insufficient for the harms that we have seen in the past 10 to 15 years. And one proposal to perhaps overcome that is to see data governance as a triangle. What does this mean? We tend to think about regulating data as a gradient, where, just to simplify, on the one end, we can have a free market-like system where the sources of obligations are mostly sourced by the agreement between the parties, So there's a privacy policy where a company commits to a number of obligations, and a person that accepts or rejects that privacy policy, and that privacy policy is a source of obligations, or a heavily regulated system where the source of the obligations is whatever the legislator prohibited. So we could say that facial recognition is prohibited. We could say that a certain data practice is prohibited. But the problem with that is that shifting from a contract system to a direct regulation system extends the basic problem. It extends the basic problem because in the same way that individuals find it impossible to anticipate these harms in advance, to consent or not consent to them, legislators and regulators also find it impossible to anticipate these harms in advance, to allow or prohibit them. Because most of the harms that we saw do not depend on a particular kind of activity that can easily be prohibited. Rather, they depend on context, they depend on the different uses of information, and they depend on things like what inference arrived at that not even companies can know the moment that they start issuing a data practice. So what we lack is a system of accountability. We lack accountability for the consequence of data practices. Companies have to commit by what they promise people in their privacy policies. Companies have to commit to doing whatever the legislator mandates in terms of procedure in advance, such as doing a privacy impact assessment, having a data protection officer. But the consequence of the data practices do not have any form of responsibility or accountability tied to them. So thinking about data as a triangle means thinking about three corners when we think about governing data. On the one hand, the responsibilities that companies commit to when they make promises to consumers, both in their privacy policies or on their website. On the other hand, whatever the legislator prohibits in advance, but also a system of responsibility for the consequence of data practices. Now, the way that this is different from most of the responsibility systems that we have in current legislation is that responsibility systems such as the one in the GDPR produce responsibility when a company breaches either a contractual promise or a regulatory provision. But that means that all of the harms that companies can produce while complying with those promises and complying with those procedural regulations escape the legal system. Having accountability separately from procedural violations and from the promise that companies make sounds radical in data protection because it's simply not the way that we're used to thinking about regulating data, but it is absolutely normal in most other areas of the law. Think about driving, for example. When you drive a car, there are lots of things that direct regulation tells you that you need to do. You need to have your lights working. You need to have your mirrors working. You need to respect the speed limit unless you're in a highway in Germany. And all of those things you have to do because legislators know that if we do them, the risks are reduced ex ante. But legislators are also keenly aware that there are lots of things that we don't know about how to reduce the risks of accidents. So besides doing all of those things, we have to drive carefully. And if we have all our lights working, we have our mirrors working, we respect the speed limit, and we crash, and the judge determines that we did not drive carefully, we're responsible for the consequence of the accident nonetheless. That means that the law has a safety net to patch all the harms that regulators couldn't anticipate ex ante, with very specific rules would eliminate those harms. So what does this mean? What do we need for a system like this to work for privacy? Well, the main thing that we need is to overcome what I call the privacy fallacy. The privacy fallacy is the idea that privacy is a social good worth protecting, perhaps even a human right, depending on what country we're in. But we could protect privacy simply by preventing the negative consequence of privacy violations. Falling for the privacy fallacy means thinking that the victims of the TransUnion case only had as a harm the cars that they didn't get, the apartments that they didn't get, and the jobs that they didn't get, and not the violation of their privacy by creating a wrongful inference about them. Falling for the privacy fallacy means thinking that if Anderson didn't lose any copyright money based on the images that were released about her, she suffered no harm because we place no actual value on her privacy. Falling for the privacy fallacy means thinking that if we have nothing to hide, we have nothing to fear. because under that view, privacy is only valuable for the negative consequence that it prevents. So as long as there are no negative consequences, we should not be worrying about our privacy. If we want a system for which we hold companies accountable for privacy violations, we need a notion of what privacy is beyond those material consequences. And that would allow us to do an important thing for AI regulation, which is having collective mechanisms that match the collective harms that AI produce. So as mentioning at the beginning, most AI harms are not anymore very marked harms to one particular individual, but rather harms that are dispersed to large amounts of the population. And they disproportionately affect vulnerable individuals as vulnerable groups. So having a collective mechanism that matches that collective harm system is just fitting. This could be a representative action system for harms or a class action system for harms, or it could be something else like mechanisms of competition law that go with data protection law in a collective way. So if you remember one thing from this couple of minutes, I'd like to be this. That's Mark Zuckerberg giving a talk with the model that Facebook used for its initial public offering that they sent to the first few shareholders of Facebook. So they came up with this model that said, move fast and break things, meaning that if one is not breaking things, then that means that one is not being innovative enough or disruptive enough, and one had to move fast and break them. Facebook abandoned that model quite quickly, but it still echoes in Silicon Valley, and it's used in two ways. It's either used by sections of the tech industry to say that this is still true, and they need to move faster and break things, or it's used in sectors of public policy to say, look at the tech industry that doesn't care about the consequences of their actions. But to be fair, besides the moral outrage that we could have about this, we have given no incentives to the tech industry to do anything else than move fast and break things, because we have given them a system where as long as they comply with promises and checklists, the consequence of what they do don't matter. So if we want a system where tech companies do not move fast and break things, we should think about how we can make them pay for the things and eventually the people that they break. So that's the cover of the book, which I thought I should show you because I didn't bring copies. There is a little website with more information if you're interested. If you are on the Oxford website, you can get to the library free access to the ebook. So if you're interested, please take a look. And thank you very much for your time.
Yeah, thanks so much. That was super, super interesting. Really, really great topic. I'm going to hand it over to all of you in just a second, but I'm going to...
We can monitor this.
Oh, yes, I'm going to go over there. I do this for you.
Okay.
But before I hand it over to everybody else, I'm gonna use my privilege here to ask a couple of questions by myself. I find that whole topic extremely fascinating. And there are two things that I'm particularly interested in. And one is just from a normative philosophical perspective. Do you think that with the proliferation of AI, that somehow privacy laws and data protection laws and maybe non-discrimination laws are kind of starting to meet in the same room, and that there's a lot of overlap of that? Not just in terms of like the harms that could occur, but do you think that those two policies are more interlinked than they used to be?
Yes, I think so. And that's because AI is mostly fueled by personal information. So because AI is mostly fueled by personal information, it at the same time creates challenges for privacy and data protection law that they haven't seen so far. And privacy and data protection law are a unique opportunity to regulate it in ways that other branches of the law can't. That's a good and a bad thing. It's a good thing because we could use tools that we have in privacy and data protection law to prevent lots of risks and lots of harms. But it's also a bad thing because it risks privacy and data protection law becoming the law of everything, where they take over every other field of law. That is not a huge problem if our privacy and data protection laws are structured based on principles that we can flexibilize and we can apply differently. But it is a problem if we have them highly proceduralized, because then everyone needs a data protection officer. Everyone needs to comply with the privacy impact assessment, and that creates problems up front. So I do think that they start to converge, and the best way to react to that convergence is to think about what are the things that we really care about in privacy and data protection law. What are the things that this body of law is trying to do? Go back to those first principles and try to use them to find compatibility with the purposes and the values that other branches of law, such as anti-discrimination law, are trying to achieve.
Excellent. That actually leads me to the second question. I'm going to hand it over to you, I promise. And so you mentioned that, and we talked about it before you had your talk, that notion of if you have nothing to hide, you have nothing to lose. And I teach this in my own classes. The first thing that I say when we start the privacy lecture, and hopefully then I convince everybody that that's a very silly statement to make. But you will probably agree that very often when you talk to people who are not privacy lawyers, they don't see the value of privacy anymore. What is it that you tell them? Why should they care about privacy? What's the value of privacy other than those harms like reputational, financial harm? Like, what is the value of privacy minus the hurt and the harm that comes from it?
Yeah, that's such a good question. So I think when people say that they don't care about privacy, what they actually mean is they don't care about confidentiality or certain pieces of information. And whether they care or they don't care about privacy depends on what we mean by privacy. So if someone, say, had an open Instagram account, so they said, I don't care that much about my privacy, because they phrase it that way, because they don't want that information to be confidential, and they just have the Instagram account opened. And then a coworker got it, selectively picked a couple of pictures from that, printed them in color, blew them up in posters, and pasted them all over the workplace. I would bet that the first person would at most be kind of upset and at least find it kind of weird. They wouldn't say, oh, who cares? I don't care about my privacy anyway. And that shows that privacy is not about keeping those pictures confidential. Privacy is about the information flows that we consider socially inappropriate and the information flows that we don't. And when we change that framing of privacy, I think most people have certain preference about how to keep certain information flows appropriate. They may say something to a bunch of friends and they wouldn't like it those friends share it further. They may share information with each other through a social network, and they may be upset if the social network then sells it through a third party. Grindr, gay dating app, faced a historic fine a couple of years ago from the Norwegian Data Protection Authority, which I'm sure you know about, because it shared information from their user base. So it basically shared who's gay, and information of the HIV status of their users to third parties. And the argument from Grindr was, well, in our privacy policy, it said that we can share the information with third parties. So what's everyone so upset about? So what that shows is that people that put on profiles that anyone with an anonymous account can see that they have a sexual orientation and that they may or may not be HIV positive did not consider that information confidential. But they did get upset to the point of filing lots of complaints to the Norwegian Data Protection Authority when that was shared to anonymous third parties that could go to potential governments or other companies or insurance companies. That is not because they forgot that that information was public at the moment that they created the profile. And it may not even be because of the material harms that they are afraid of, but just because they were trying to communicate that information with each other and not to those third parties. And I think that's what privacy is about.
Yeah, that's very interesting, especially with the Grindr example. I think a couple of years back, there was also a case where when you downloaded the app, it would give you a recommendation to download other apps. And one of them was whether you're interested in a sex offender register database.
Oh.
So there's an interesting inference for you.
Yeah.
So that's a whole other harm that comes from that,
Right.
which is quite interesting as well.
Yeah.
But yeah, I have more questions, but I will restrain myself and then throw the ball over to you. Anybody who wants to ask any questions? Yes, go ahead.
Of course, I'm a reliable audience member for such matters. I'm interested in the distinction. I mean, I'll proffer this distinction, but you might not love it. But between information that is denotative and information that is connotative.
Okay.
And where, you know, denotative information would be, I guess we call it literal information, you know, it's a photo, it's a document.
Yeah.
And we're often talking about the privacy of such information, your specific status.
Yeah.
But connotative information is implied, it's, you know, suggested, it's an inference.
Yeah.
And so when we compress all this data down, we're left with all the connotations. Letting people, you know, people saying, I don't want to have like my name and my face and my phone number or whatever in a database is quite literal and coherent. But how do we explain to people about their kind of inferred data shadow? It's not like, you know, it's not literal information. It's often a vector of similarities. It's an abstraction. It's a vague representation of your face, but yet it still can identify you. It can still link you to other people. It can still be recognizable if you render models based on it. And I'm having a devil of a time trying to explain the PII as an abstraction from PII rather than PII as just like, it's your phone records.
Yeah. So I think you're putting an unfair burden on yourself, because the point is you shouldn't need to explain that to people. We need to explain that to people because we have a broken model where we expect people to self-protect. And if people don't self-protect, there's nothing that we can do about them. But we live in a world of collective harms, not individual harms. So the thing about information that is not necessarily about one person is that, first of all, it is harder for that person to predict the risk. And second of all, it has distributional effects. Information that is not about one person, but is potentially about one person. First of all, it's information that could be potentially re-identified, because de-identified, for example, but it's also information that is informative about groups. So it's informative about everyone that has a certain group membership. So there are distributional justice issues in having one person release information that may not necessarily be about them, but is probabilistically about a certain group, and that can affect other people. And that goes from daily examples like putting an Amazon Ring camera in front of your home that films a bunch of other people that is not you, to sharing information with a social network that then could provide probabilistic information about vulnerable individuals to a number of other entities. And it's unfair to expect every person to take on that responsibility. What would be fair is to have a system where there are collective protection mechanisms for those collective harms, because that is what the law does for most other profitable activities that have unintended spillover consequences for others. So I don't know if I have a good answer about how I would explain it, but I do have strong views that we shouldn't need to. I think maybe the best way to explain it to people would be to say that your information is not only information that identified you, but information that can identify you, and information that can identify others. And we tend to trip up on this when we're talking about data protection, but that is something that we intuitively see for most types of knowledge. So if I say, oh, it's going to rain tomorrow, I don't have certainty that it's going to rain tomorrow. I think that it may rain tomorrow. Maybe I look at the forecast. Maybe I look at the clouds. We would call that knowledge, because we'd say that, oh, I know that it's going to rain tomorrow. Or I may even say, I know that it's raining because when I walked in, it was raining, but I don't have absolute certainty. There's almost nothing in the world that I have absolute certainty over. So why would we then change and say that to consider something information about someone, it cannot be probabilistic? We need absolute certainty that that information is true. That not only ignores the fact that probabilistic information produces real harms to individuals and groups, but also violates basic intuitions about how information works and how knowledge works.
Thank you.
Yeah, go ahead.
Oh,
Yes.
I think maybe this is related to the last question.
Yeah.
So you suggested that many privacy-related harms we're worried about are things we couldn't anticipate, you know, individuals couldn't anticipate, and also the regulators couldn't anticipate them. So maybe I'm getting caught in the weeds here, but if that's the case, I guess I'm struggling with the idea of accountability for harms that can't be anticipated.
Right.
Because is the idea that you're held accountable, like a company is held accountable for things that they didn't anticipate either? Like,
Yes.
Yeah, could you, I don't know if you could elaborate on that a little bit?
Yeah, it's exactly that.
Okay.
So, and that's, I mean, that sounds radical, but that is how the law deals with a lot of other things. If I, So if we could read technical, in tort law, we separate accidents between unilateral accidents and bilateral accidents. Unilateral accidents are accidents where only the potential tortfeasor or the potential inflictor of the harm can affect the probability of that harm happening and the magnitude. And bilateral accidents are those in which the tortfeasor and the victim, by levels of care, can adjust the probability of that harm happening. So for example, driving, when I'm a pedestrian and I walk around, there are lots of things that I can do to prevent being in a car accident as a potential victim. I can look around, I can check the lights, I can, even if the light is green, I should look that no cars are coming. All those things will help me not get run over by a car. If my neighbor has a pet tiger, that is usually very well behaved, there are very few things that I can do to protect myself from the pet tiger. I mean, I can be away from the pet tiger, but if I engage with the pet tiger, there's almost nothing I can do to protect myself. The law says that for the first one, the person is liable only if they're negligent, because that rule makes it so that victims also are careful. But the law says that for the latter, they're liable for whatever harm happens, no matter whether they were negligent or not, because that will internalize the consequences of their behavior, regardless of the victim behavior. Data accidents are unilateral because there's nothing we can do to escape them. Even if we have a flip phone, if we don't have smart home devices, if we don't agree to being in talks that are filmed, none of that matters, because in a world of inferential relational data, we're exposed to almost the same data harms. So if behavior from people doesn't matter to avoid them harm, we don't have good reasons to only compensate them and only deter the harm that could actually be predicted by someone.
That's helpful. Thank you.
Okay, so I'm going to ask a question and then give context to the question. So the question is somewhat simple. It's, what would effective collective protections look like for privacy? The context here is coming from some of the work I did on group privacy, which is, I was thinking about that myself. The closest thing I got to is something like a class action lawsuit. And the problem you run into is people won't know that they're members of groups. They won't know what the groups are actually defined by. And there's not really any one person that can justifiably speak on behalf of the group or pursue the action on behalf of the group. So just curious, like, what would those protections look like?
I'm actually a big fan of class actions. And I think all of those three risks can be minimized. And even if we don't touch those limitations and class actions come out with those limitations as they are, they will be an improvement over the current system, even if marginal. So I think the important thing when we want to have a class action system is, first of all, to get over the idea that the only harms are the material harms, because then it will be impossible to certify a class. The point of collective mechanisms is to recognize collective harms. So if we want to address the collective harm, the collective mechanism, we have to unify the class actions based on a harmful data practice that is harmful to people's privacy. And then we can either have subclasses or different levels of compensation within the class for the different material stuff that they may have. The right answer from the Supreme Court in TransUnion should have been, you all suffered an inferential harm by being flagged as terrorists mistakenly by the credit rating agency. This group also suffered this material harm of not getting a rental car. This group also suffered the material harm of not getting an apartment rental. I'll adjust the compensation quantities, but I'll certify the class based on the immaterial harm. And I will give some sort of compensation, even if minimal, for that immaterial harm. And if we just do that, class actions would have a drastically different effect. On the second point on people don't always know when they're harmed, that is true. There's still a larger proportion of people that know about a harm after it happens than the proportion of people that can anticipate a harm before it happens, which is what the law currently expects them to do. So even that would be an improvement. But we could even get over that improvement by having an opt-out system of class actions, or by having representative actions, where an NGO sues on behalf of a large number of people. I think that would significantly improve it as well. And I mean, know the papers that I mentioned because I cited them in the chat.
Excellent. Actually, I have a couple questions online as well. The first one is, how do you respond to the economic incentives in today's global economy that encourages users to share not so critical personal information?
Not so critical. Can I ask for a clarification to
I
another
think
question?
I'm reading this as that people are being encouraged not to post
right.
too much personal, intimate information online. Whether that's a way of mitigating the things that you worry about, but just telling people just don't share something that you don't want your parents, your boss, your enemies to know.
Right. I think that's really unfair, because we live in a world where our sexuality, our political affiliation, and our ethnicity can be inferred from our Spotify listens, our Starbucks orders, and our text messages. So not sharing sensitive personal information does very little for us in a world where sharing insignificant sensitive information creates sensitive inferences about us. So asking people don't share the things that could potentially be harmful puts a lot of pressure on them, because it tells them you're not going to be protected in this economy if you share those things. It is your responsibility to not share them. And then at the same time, and companies can infer them about you anyway, even if you choose not to share them. So I sometimes think that there's a bit of victim blaming when we tell people, why did you share that online? That was silly of you. When that sometimes is part of engaging in meaningful social relationships, and not doing it would have not prevented them harm anyway.
Excellent. Second question from online, from somebody who is a business ethicist in Germany. And the question is, my question is, how can ethics take a more positive outlook towards tech companies, encourage more innovation without the current doom perspective they have for tech on the island innovation? An easy one.
Yeah, exactly. Yeah, let me just solve that in 5 minutes. Two of my favorite principles in data protection law that I think work very well as ethical principles, particularly while supporting AI innovation while reducing harm, are privacy by design and data minimization. Privacy by design, or data protection by design, is the idea that we need to think about the different elements that we care about in privacy and data protection from the moment that we start building a product, in the different features that it has. So privacy by design, for example, means do not use dark patterns, because that deceives people. Privacy by design means try to simplify the options if you can, make it easy for people to choose in the very limited circumstances where they may have actual choices. Data minimization is about using the amount of data that you need for a specific purpose, and not more than that, because the more data that you collect and the more data that you process, the larger the risk. So why would you produce a larger risk if you don't need to produce a certain product? I think those two things can get us very far. And just more broadly speaking, a notion of what consequences do we foresee from this particular product, and how can we minimize the negative consequences while allowing for the functionality of the product can go a long way. That is what we saw to a large extent when we were having the discussion on contact tracing apps a couple of years ago. Contact tracing apps were really important to contain the pandemics, or could have been really important to contain the pandemics if they had worked. But most of the conversation about contact tracing apps was an unsatisfying binary distinction, where people presented it as, we need to balance privacy against public health. Who wins? Public health wins. Okay, so we forget about privacy. We make the most privacy invasive app that we can, and then we roll it out, and then no one wants to use it because it's privacy invasive. How about we think about what things do we need for the app to work, and then we try to minimize privacy risk conditional on that functionality? I think that would be way more significant data ethics that lots of companies actually do try to implement, and more of them could.
Excellent, thank you. Anybody else maybe in the room? Yeah, please go ahead.
I guess my question is about the failure of the procedural rules and the ex-ante regulation and the liability solution. So some scholars have presented like information fiduciaries as one solution that I think speaks to that a little bit, but then others have proposed a right to reasonable inferences, and that might be a more procedural solution. So we have the fairness principle with the UK GDPR. et cetera, when an inference is identifiable to an individual, all the framework applies.
Yeah.
So I guess what's do those sorts of things go some way in achieving what liability aims to achieve, I suppose?
Yes, yes, they go larger because both of them are trying to think of the back end and not the front end. So information fiduciaries, for example, gets to the idea that we cannot have specific ex-ante protections that will eliminate all harms. So it creates a duty to be loyal towards the users of a certain company. It has lots of critiques that I think some of them are unfair, that a liability system doesn't face. But information fiduciaries is an important effort to try to create that accountability. And similarly, the right to reasonable inferences is enormously important because it shows the importance of inferences in the information economy. And if we take that right to reasonable inferences further, if we take seriously the idea that inferences are information, then we see that much more breaks down. The idea of control over personal information is really difficult when we take inferences seriously. How can a company possibly ask for explicit, meaningful consent every time they want to make an inference about someone? How can we say that someone has control over their personal information if information is inferences that are collective? What does it even mean to have a right to know, object, withdraw, be forgotten in a context where information is inference that are not only about one, but about groups? So I think it is a really important step in this direction of accountability because it shows us all the problems that the prior system had, both of those ideas.
Yeah, I wanted to learn a little more about how this, instead of focusing on this procedural system, you want to develop something based on accountability. How would you then think about, let's say you gave the example of a car where if there's an accident, even if you didn't break any rule, you're still liable. But is the car company liable? The place you bought the car from, the person you rented the car from? A lot of tech companies use this defense that, you know, they're just a platform and someone else made the post or said whatever they said. So who is accountable in that kind of situation?
I think it depends on the data flow. So one would have to analyze a particular data flow that one found harmful and then see who is involved in that data flow. That could not necessarily, that doesn't need to necessarily be anyone that created any product that was involved in the data flow, but it probably would be more than one entity. And within those people or those entities that were involved in the particular data flow that one found harmful, then a good system could be joint and several liability or solidary liability, as they call it in the common law. So have the group of people that want to sue be able to sue any of them for the full amount, and then entities that were involved would sue each other depending on the percentage of responsibility that they can convince a judge that each of them had. Expecting people to know exactly who to sue within that data flow is too onerous, because there's a strong asymmetric information between the people that are harmed and the entities that harmed them. But it is not onerous to ask those entities to figure out or to convince a judge what is the percentage of culpability or what is the percentage of negligence between each other, because they're the ones that have all the information. So it's something that we do for products liability, also because of this differential information. I think we could do it also for privacy and data protection.
Anybody else here? I have still a couple online, if
Okay.
that's okay.
Yeah.
I have a couple minutes still left. This is about privacy and privilege. So privacy seems to be a privilege. Marginalized groups are being increasingly brought into the digital folds and subject to algorithms, for example, credit scoring. While consent exists, it's more of an illusion, and yet is required to get access to data and to basic services like loans. So how do we navigate the tensions between privacy, consent, and access, especially with a focus on privilege?
Yeah, I mean, my response is just strong agreement. And maybe in the current system, we can't navigate that, because the point of information is that it has distributional effects. So people that have more privilege could share amounts of information that are not harmful for them, but then are harmful for others because of the relational nature of that data. And well, now, and sometimes privacy is presented as a privilege. And in those cases, I think it is not exactly accurate when you have products that are paid for. Facebook, for example, now has an option where you can pay instead of being shown ads. And that's an interesting example because sometimes that is presented as a tension between, oh, you can pay for privacy, or is privacy something that we should allow people to pay for and have? But the irony of that is that you don't get privacy if you choose to pay for Facebook. You don't get shown ads, but your information is still collected, your information is still processed. So the privacy aspects don't change at all. So I think there's a double aspect of that, in that if we continue to have a system that is based on individual consent, while we have spillovers for information, we'll continue to have a system where people with more privilege can have more privacy. But the paid systems that we have that we often criticize for that reason are not necessarily a privacy improvement. In those cases, people with more money do not get more privacy because they get their information their information processed anyway. They may be less subjected to harms because of the positions of privilege that they have, but that's at the back end and not at the front end. So that's why I think a system of accountability would be important, because systems of accountability for the consequence of data practices, as opposed to systems of control based on consent or at the front end, do not have that distributional issue that we currently have.
Anybody else? I had still one question.
Okay.
And it's an unfair question. It's an unfair question because I get that question all the time and I don't like it at all. Because I think it's a silly question, but I think I'm just very curious what your response is, because I agree with everything that you said. And I love the idea of having somewhat like a strict liability regime like that. That makes my German heart.
Germans are great at strict liability.
I never love it. It's fantastic.
I don't know why the common law is so resistant to it.
I don't know either. It's crazy. So I'm with you. Whenever I go out and say, oh, we need more regulation and more liability, people come to me and say, well, but what if the companies then go somewhere else? Right?
Oh, right, yeah.
And they all pull out of the market and we don't get all the products in the European Union or wherever it might be. Like, what if like Google just closes their shop and moves somewhere else, right? That's the thing that I always get thrown in my face. I'm sure you too.
Yeah.
What would you respond to the idea that, regulation stifles innovation and makes the economy collapse?
Yeah. That is another question. I think there are two dimensions of it. One is the jurisdictional dimension, and one is the stifling innovation dimension. On the jurisdictional dimension, I'm just skeptical of the idea that if you try to regulate a company, they would pack up and leave, simply because that is the argument that has been used for almost every type of significant regulation for the past 100 years. And if an argument applies to everything, sometimes I suspect that it applies to nothing. So I'm somewhat skeptical of that. And it is true, data companies are not tied by factories in the way that prior companies are, but they are tied by tax law. They are tied by large servers. They are tied sometimes by underground cables. So there is a certain infrastructure that does, I think, anchor companies to certain places. There are also non-infrastructure aspects that tie them from the type of law to simply getting a large consumer base. So I am somewhat skeptical that they would necessarily pack up and move and lose part of the world as a market. And on the regulation stifling innovation, certainly regulation stifles certain kinds of risky innovations. And I was talking about driving earlier. That is the same argument that the automobile industry used when they started mandating seatbelts. How can we possibly build cars with seatbelts and airbags? That's outrageous. You're stifling the automobile industry innovation. True, you're stifling what kind of innovation, which is cars without seatbelts. But you're rather redirecting innovation to something else. Is it a bit expensive? Yes. And the same thing works for this. Regulating an activity that has harm for others while it's profitable is something that we do all the time for profitable activities. But I think even more important than that, accountability mechanisms, unlike ex-ante regulations like acquire explicit consent, get a DPA, do not impose costs on everyone. It only imposes costs to companies that actually produce harm. So in some sense, they're cheaper. They're cheaper because they're lighter on smaller players and produce less harm than bigger players. And they reduce barriers of entry. And they do not produce the same regulatory weight for companies like DuckDuckGo that will gather very little information about you to run a search engine than for companies like Google that will gather a lot of information about you to produce a search engine. So would it be more expensive overall to have a system with accountability than one without? Probably. But that wouldn't overburden small players, and it wouldn't be more expensive for everyone in a way that if that goes also with reducing some weight from the ex-ante regulations that we don't think are very effective, like collecting explicit consent for disclosed information, the system may overall even be cheaper for some.
Excellent.
I think we have.
Yeah, Vicky, go ahead.
If we have time, just one last question. So it's fascinating talk, and I think it is such an interesting proposal. I'm really aware we've talked about companies all the way through.
Yeah.
And of course, the other big actor that collects large amounts of data and uses it for inferential
Right.
purposes and often discriminatory purposes are governments. And
Yeah.
so I just wonder, how do they fit in here? Do you think this regime would also protect citizens against the worst successes of information harm from government?
The tricky answer is that I don't know. And yeah, I explicitly was referring to the information economy because I constrain my arguments there because I do think that there are lots of relevant commonalities with governments, but I also think there are lots of relevant differences. The main relevant difference is that when we have a system we want to internalize all harm, internalizing all harm is just and it is effective when one has an entity that internalizes all benefit. I don't know if a government internalizes all benefit from the data that it processes. It probably internalizes most benefit, but not all, at least if it's working like it should be working. So that aspect is probably slightly different from companies and from the government. But certainly, the inferential harms are common. So the problem is the same. The solution may be slightly different. The interesting irony is that we're very used to the idea that individual consent is not an effective mechanism for government surveillance. We just thought that it was for corporate surveillance for some reason. So maybe this is about also learning from the things that we know from government surveillance to think, oh, all this power that we knew governments had all along, that all of a sudden now private companies have, means something. And that means that these little consumer-like mechanisms that we thought would protect people in the private sector don't protect them anymore. And maybe as we think of accountability mechanisms in the private sector, we can also start developing more robust ones for the public sector. And that will allow us to go a bit further than just transparency. Some accountability from governments would be good. I don't know if strict liability would be the answer. Maybe a negligence rule would be the answer. But consequences for the harms that surveillance produces so that when they make choice about what to surveil and what not to surveil, they're mindful of the benefits, but also the risks in one single decision, I think would be effective.
Can I have one more online question? I know we're running a little bit over time, but people were very, very eager to ask questions here. I'm not going to go through all of them, but maybe the last one for today. What are the long-term consequences of overlooking privacy concerns in the pursuit of technical advancement? How can legal frameworks be adapted to address evolving challenges posed by the information economy and its impact on privacy rights?
I think it's about regulating privacy and regulating AI is always a delicate balancing between things that are overly specific that we think will give us some traction, but will be outdated very fast, and things that are overly vague and do not give us much traction because we don't know what they mean. Maybe an example of the first is the cookies directive a couple of years ago, which not only created lots of useless cookie banners in terms of automatic consent, but also doesn't cover the metapixel, doesn't cover fingerprinting, doesn't cover headers. The problem was that people that designed the cookie directive were so obsessed with the technical aspects of it that they regulated as devices installed in your computer. What they should have been worried about is the social and economic dimensions of tracking. And they would have been better if they had had a rule or a principle that tried to regulate tracking and not trying to regulate devices in your computer. So that was a fail on the too specific end. The AI Act in a number of places is a fail on the other end, on the end of being too ambiguous. trying to be so worried about not passing a piece of outdated legislation. There are parts of the AI Act that I have no idea what they mean. And so it's a difficult question. It's a delicate balance, and there's no obvious answer. I think being aware of that spectrum is already helpful, and trying to be somewhere in the middle, trying to have enough flexibility so that the law can adjust to changes in technology while having enough tractability that it actually means something. And I think key to trying to find that balance in the middle is trying to be technologically neutral. So being aware that AI, as other technologies, operates over social and economic relationships that already exist. And the reason why we may want to regulate AI is not because it has certain technical specifications, but rather because it changes those social and economic relationships in the way that the law cannot capture because the law couldn't anticipate them. So if when we pass laws and we pass regulations, we'd rather focus on those relationships and the risks and harms that they can produce, and not on the technical aspects, we can produce principles like data minimization and privacy by design and accountability and maybe information fiduciaries and responsibility for inferences that have a certain content, but also can maintain as the technology that is under them changes.
Excellent. That was absolutely fantastic. Thank you so much.
Thank you very
for taking
much.
the time today. Round of applause for